Welcome. My name is Dr. Alessandro Corda. I'm a reader in criminal law and criminal justice in the School of Law at Queen's University Belfast. And I'm joined by my colleague, Dr. Elisabeth Agnew, and our guest, Dr. Clara Rigoni from the University of Lausanne, to discuss her book, Honor-Based Violence and Forced Marriages, Community and Restorative Practices in Europe, published by Routledge in 2023. Clara, many thanks for joining us for this Law Pod episode. By way of introducing the topic to our listeners, who may not be aware or familiar with some of the terminology used in the book, could you please tell us what you mean when you talk about honor-based violence?
Well, honor-based violence is an umbrella term which brings together different forms of violence, different offences, such as forced marriages, female genital mutilation, certain forms of domestic violence, controlling behaviour, sex-selective abortion, forced pregnancy, and many others. In my book, I used a definition that was given by the UN in 2011 while developing legislation on violence against women and guidelines for member states. They define honor-based violence as composed by three elements: control or desire to control of a woman's behavior, a feeling of shame over this loss of control, even only a perceived loss of control, and then a third element, which is the characteristic of honor-based violence, which is the community or familial involvement in addressing and augmenting this shame. This is actually what differentiates honor-based violence from other forms of violence against women and family violence.
Thank you. This is very helpful to set up our conversation. So could you please tell us, how did you become interested in this topic?
Well, the book was a result of my PhD that I did at the Max Planck Institute for Foreign and International Criminal Law in Freiburg during 5 years. But the interest in this topic stems from way before. I started working on so-called culturally motivated crimes, cultural offences, already during my master in Bologna, the University of Bologna, where I looked at the use of so-called cultural defences and the concept of citizenship in Canada. And I started looking at what role does culture have, or could culture have, or shall culture have in criminal law. Culture broadly understood, meaning also religion, tradition, customs, etc. And I started looking at different possibility with the instruments that we have at our disposal, for example, justification, excuses, mitigating factors, mistake, etc. And at the end of these studies, I realized that there was not really a satisfactory solution, especially in cases that are considered highly problematic because they affect seriously individual rights and the individual well-being, for example, like forced marriages and honor-based violence overall. And then during my master in human rights that I did between Venice and Utrecht, I wrote my final thesis on restorative justice with a focus on offenders' rehabilitation, and started working on this separately, also with the focus on legal pluralism and informal dispute resolution mechanisms, looking also at both the benefits and the risks linked to the use of such mechanisms and instruments. And so I decided later on to bring these two elements together and start looking at solutions that could serve the area of culturally motivated crimes, especially those seriously problematic, such as honor-based violence, while looking at solutions that are not necessarily within the systems, but also outside the criminal justice systems, however possibly connected to it. And this led me to conceptualize the research question that I tackle in the book, which is basically whether alternative solutions exist, which, when applied to cases of honor-based violence and forced marriages, are capable of avoiding, on the one hand, the shortcomings of criminal law-based responses, and on the other, the problems that are generally associated with alternative dispute resolution mechanisms.
Thank you. It's really interesting to hear that journey from your PhD right through to now what we have in front of us, which is your book, the final product of all that. You note that the term honour-based violence has been criticised, and there has been debate about whether the word honour and the positive connotations that that word often denotes should be used alongside a word such as violence, which suggests obviously that some form of harm has been caused. But in your research, the word honour was a key theme that emerged from your interviews, and it seemed to be quite a significant motivating factor in terms of your findings on honour-based violence. Can you explain to us a bit more about your findings here and whether you think honour-based violence is actually the appropriate way to describe the behaviour?
Yeah, this is true. The term honor-based violence is criticized from many different sides. And as you mentioned, mainly because of this positive connotation that we are used to attribute to the term honor, which instead here is used to connotate something very bad, such as violence. There are also other reasons why the term honor-based violence is criticized in the debate. First of all, some scholars think that creating a parallel category of violence against women using this term can shift the attention away from the main problem, which is gender as well here, and create a parallel debate, and therefore, in a way, also putting at risk the overall system. There's also criticism because honor-based violence tends to focus on culture and might risk facilitating processes of othering and marginalization towards certain communities, stigmatization, etc. Also, this idea that culture is treated according to somebody in a homogenic way, as a homogenic discourse, might silence female critical voices within these communities in which honor-based violence mostly happens, and also might justify a sort of a misuse of cultural relativism. However, why I think it is important to use the term honor-based violence or any other term that differentiate these type of violence from other forms of domestic and family violence is that there are certain specific elements that make the dynamic very different. So in my findings, what I observe as elements that are present within what I call honor-based violence are mainly four. There is, of course, a relevant aspect of gender. So women's sexuality and the control of women's sexuality is at stake. And it's the real motivation that triggers this type of violence. There is, however, an element which we call agnation, meaning that the perpetrators are usually the relatives, often from the father's sides, mostly the father, the brothers, the uncles, often also the grandparents, the cousins, with the participation also of the female relatives and female family members. There is what is very important, I was referring to it during the first question in the definition of honor-based violence, a collective element, which is the involvement of other family members, not only the main perpetrators, in either the preparation or the perpetration itself and the control of the woman. And then there is a discourse on honor, which is present everywhere. I also interviewed certain victims, some victims of honor-based violence during my research. And this honor element came up in their narrative as well. It was because of honor, it's because I am a woman and there is honor linked to it. So I don't think it really matters how we call it, but we need to identify what the elements of these type of violence are. So honor-based violence is not a legal term. It's not, we have no such offense as honor-based violence. We have forced marriage, we have female genital mutilation, but there's not such thing as an offense of honor-based violence. But what we need to recognize is that dynamic is different because it is collective. And that matters very much in the prevention and in the repression of such violence, especially when we assess and manage the risk to which the victim is put.
Yeah, thank you. And that leads nicely, I think, into our next question then, in terms of your book and highlighting the shortcomings of criminal law-based responses, and you propose alternative community-based approaches. And I wanted to talk specifically about one piece of legislation that you mentioned in your book. In 2014, the Antisocial Behaviour, Crime and Policing Act came into force and introduced a new offence of forced marriage, which was punishable up to 7 years imprisonment. What I found so interesting was the narrative around that in your book, and it wasn't viewed by all as a positive legislative step, was it?
No, it wasn't, and it took quite a while to actually have this piece of legislation approved. passed because, there were working groups working on this ever since the end of the 1990s, the beginning of the 2000s. And several groups, several associations, especially community organizations, representatives and consultants, always rejected before the use of or the introduction of such an offense. There are several reasons, and I would divide them into some micro and macro reasons maybe for rejecting such an offense. On the one hand, looking at the micro level, what is contested is the efficacy of such a provision. Because of the reluctance of victims to come forward when criminal law is involved, especially when they know that their parents or their relatives will be criminalized. But this is something that has been discussed also very much for domestic violence cases in the past. And now we all agree that this is not a good reason not to criminalize domestic violence. But the problem is also linked to the high standards of proof that criminal law requires and the fact that we have other measures that could be used, such as, for example, coercion, or we also have forced marriage protection orders that entail also criminalization when breached, that might better respond to these, according to some practitioners. We have also the sort of macro level rejection of the offense of forced marriage, which is more of a political reason, if we want. So the idea that such offenses that actually target specific groups, we know, as I said, that we have general provisions on coercion that could very well criminalize such behaviors. Adding a ad hoc criminalization of forced marriages, often higher punishment, this is, for example, the case for female genital mutilation, might actually stigmatize and target specific groups. We have a study that was conducted recently in Bristol on policies adopted to combat female genital mutilation that has shown how these measures can be counterproductive, can actually increase the targeting, the racial profiling in certain communities, and might lead to a polarization between these communities and the institutions of the state, especially law enforcement agencies, and therefore also maybe reduce the reporting rate instead of increasing access to justice in these communities.
Yeah, and I suppose then in response then to the limitations of criminal law that you have spoken to there, can you also elaborate on how alternative community-based approaches address victims' needs more effectively, and what safeguards are necessary to prevent, for example, potential misuse or power imbalances within such programs?
Sure. Well, actually, we see how criminal law is actually not able to tackle very well these type of violence and these offenses. Also by the numbers, we have really a handful of convictions overall in Europe for these crimes. We have very low reporting rate. We have problems both in accessing justice for victims due to, for example, certain reasons that are linked to overall every form of domestic and family violence, meaning the proximity between the victim and the perpetrator, the close relationship, reasons of privacy. We also have reasons of intersectionality because these victims are often foreigners or second-generation migrants. We have high levels of mistrust towards the police, often the unwillingness, as I was saying, of criminalizing the families. We also have very high levels of social control in such communities. And also we have problems linked to the solutions that are actually put in place by the criminal justice system once these victims enter the support system. They sometimes replicate certain dynamics, certain control dynamics. They might not be able to take a taxi. They might be relocated several times in areas where there is no presence at all of the community of origins of the victim. They might suffer from loneliness, of course, and they also might suffer from PTSD since there might not be a closure found with the family, and they might actually live within this threat. However, we know also from research that alternative dispute resolution entail a certain amount of risk linked to safety and power imbalance, as you mentioned. Also, when we talk about community programs, especially, we have a risk of discrimination, of secondary victimization. We have risk linked to coercion, so that these people are forced to engage in an alternative dispute resolution mechanisms instead of actually accessing a court. So the idea is, well, to find programs that actually can overcome the shortcomings of criminal law, but also that do not present such risks. And I think in the programs that I analyzed, there were many safeguards that were adopted. The people that were involved in the programs had specific training. There was a strong knowledge and presence within the community. So the accessibility was one of the elements that facilitated women to come forward and also speak up. They had lots of expertise and also they had especially the trust both of the people, of the victim that often came forward, but also the trust of the families, of the parents. And so these people could actually act as, in a way, a proxy and set up a dialogue between the two sides. The risk of coercion and discrimination was usually very, very little because there was some sort of involvement of the institutions, especially of the police. So there was always another option open. There was always a criminal trial, and there was a framework which responded always to the legal framework of the country. But on the other hand, as an added value in a way, next to the accessibility and the expertise and the trust that I mentioned, there was really this recognition of legitimation and legitimate authority that was recognized to the mediators, for example. So the Norwegian and the UK situation in which the mediators were sometimes trained state-based mediators, and on the other side, in the UK, they were community mediators. But in both cases, we find high levels of legitimacy and authority. When possible, even two mediators coming from two different backgrounds, taking this normative plurality seriously, taking this hybridity seriously, and also trying to come to individualized agreement, able really to bring together the needs and the desires of both the victims and the parents with a long-term safety plan within, as I mentioned, the framework of the legal system. So respecting, of course, having minimum standard of rights respected in a way.
So in the book, one of the main themes concerns how to reconcile pluralism with the rule of law in addressing honor-based violence and forced marriages. How do you envision this balance working in practice? And what, in your thoughts, are the key challenges to ensuring that pluralistic approaches do not compromise women's access to justice?
Well, this was the real challenge in a way, right? I mean, we're talking about context of normative plurality, where we know that law might be highly ineffective if it does not match, in a way, social expectations, visions of justice. I use in the book a lot the concept of procedural justice, and I interrogate myself on how and why people cooperate with authorities, especially in context of normative plurality, where the internalization of the norms is difficult. So how do we ensure compliance with the norms in context of normative plurality? How do we ensure legitimacy? How do we enhance legitimacy of our institutions? And procedural justice actually brings forward the elements of participation, of neutrality, of respect and dignity, and of trust. So I started with these concepts in mind and started thinking of procedures instead of procedure and participation. So if we rightly do not want to give up on substantive norms and principle, we might instead achieve legitimacy and effectiveness of the law by broadening participation. So this is the key concept of procedural justice. We know that minority communities and immigrant communities are strongly underrepresented in the system because of, for example, the lack of citizenship, rules that prevent double citizenship. We have a lack of presence, especially in continental Europe, but partially also in the UK, of a lack of presence of people with a minority background in law enforcement agencies. So I started looking at how can we actually include them in procedures. And so I have a quote in my book by Schiff Berman, Paul Schiff Berman, who works on legal pluralism, who says, although people may never reach an agreement on norms, they might at least acquire on procedural mechanisms, institutions, or practices that take hybridity seriously rather than ignoring it through assertion of territorially based power, or dissolving it through universalist imperatives. And so I start looking at a definition of the rule of law, which focuses more on procedure, like Jeremy Waldron does, and that can offer, in a way, active engagement in the administration of public affairs to minorities instead of privileging the security and the predictability in a way. So towards the end of the book, I actually developed a sort of a state-community cooperation model, which is something that I am trying to work at the moment, although it is not simple to achieve. And I envisaged the possibility of a state-community cooperation in 3 different steps of the crime control procedure. First of all, in criminalization and policy making, so enhancing in a way the representation and consultation of minorities during the process of criminalization or the setting up of criminal policy. The cooperation and exchange of expertise between communities and state institutions during victim and offender related procedure. Everything that has to do, for example, with risk assessment, with the training of the police, with the management of the risk in a sort of a multi-agency approach. So using the expertise of the community and let them cooperate with the authority. And then finally, a state-community cooperation in the alternative program. So what I analyzed here, I analyzed both state-based procedures and community-based procedure with the aim of sort of integrating what is already present in the communities into state-based procedures. So using their expertise, using their authorities that they trust, but in a way putting forward the procedural safeguard that we have in our procedures and in our mechanisms. And this is the ultimate goal would be actually to use the strong social control that is present in these communities and that is often defined as negative social control, which might encourage certain behaviors such as honor-based violence, might prevent victims from coming forward. So turning this social control, this negative social control, into something positive, into so-called collective efficacy to strengthen the cooperation towards the communities and the authorities in crime control.
When I was reading your book, Clara, what constantly came to my mind were cases that we're seeing on an almost daily basis now of women and girls being killed or subjected to violence at the hands of men and boys, so gendered-based violence. And here in Northern Ireland, violence against women and girls has been described as reaching epidemic levels. What are some of the key similarities and differences between honour-based forms of violence and other forms of violence against women and girls?
Well, there are many similarities for sure. What I was saying before, as the element of gender is very, very crucial in all of these forms of violence. We have a control or a desire to control women's sexuality and a reaction when we lose this control from men especially. However, what I was saying earlier, there are certain elements that I think are specific to honor-based violence, such as agnation, such as collective participation, and this discourse on honor, even though this discourse can be found also in other forms of violence against women. There is this idea of a conflict of norms within, especially within the migration context or the diaspora context. So these situations, these forms of violence are often triggered by a conflict of norms, of conflict of socializations between the newer and the older generations that have been socialized in a different system. And I think this dynamic, this collective element and this norm conflict makes this type of violence different, and the context in which it happens different. And we need to take this into account in order to prevent and combat it. For example, we need to be careful during the risk assessment procedure. We need to have specific risk assessment tools that we do not have everywhere. We have, for example, in Norway, one of the countries that I analyzed, we have a special risk assessment tool for honor-based violence, which is called Patriarch, which comes up every time there is a suspect that is detected through the usual general risk assessment tool for violence against women. And so the other risk assessment tool and the expert on honor-based violence is called, and there is a different risk assessment taking place. Here in the UK is the DASH, which is used, which is the general one, but it's lacking certain elements. And it does not very much take into account, for example, this collective element. Something that, when we have a case of domestic violence where two people are in a conflict, when there is one perpetrator that is inflicting, when there is one perpetrator who is inflicting violence on the victim, we usually find, for example, a person of trust in the family that might be contacted in order to help the person. In these cases, the opposite approach is put in place. So we need to separate the victim from the overall family, even the overall extended family, sometimes from the overall community. So we have cases of victims that have been relocated 16, 17 times in order to find a place where nobody from the country of origin of the victim was present in the area, in the school, in order to put her in a safe place. These are, of course, extreme cases, but the procedure is very, very different.
So, Clara, you already mentioned them, but in the book, you analyze case studies from the UK and Norway. Methodologically, why did you focus on those jurisdictions specifically?
Well, I was looking at two main criteria when looking for case studies. The first was the presence at the national level of legislation and significant initiatives, so policies in the field of honor-based violence and forced marriages. And second, I was looking at the existence of official or unofficial programs dealing with honor crimes as an alternative or an addition to the criminal justice system, without knowing whether I would find them or not. So at the very beginning, I had informal conversations. Some countries were excluded because of reasons of not fulfilling this criteria or for reasons of accessibility, because it was a qualitative research, so I needed to conduct interviews and to have access to the mediators, the practitioners, but also the victims where possible. And I think the UK and Norway have certain characteristics that made them, for me at least, perfect for this kind of study. So they were both pioneers in the regulation of honor-based violence, including the training of practitioners and the setting up of specialized procedure, victim supports procedure, for example. But they also have different characteristics. So they have, first of all, they have an opposite approach when it comes to mediation and alternative dispute resolution for this kind of crime. So the UK officially prohibits any form of conciliation. It discourages this at any level. But on the other hand, it has a high presence of immigrant communities, an old presence of immigrant communities that are very well structured, of minorities that are structured. They have their authorities, they have their organization. And so they have quite a system of informal dispute resolution mechanisms that is in place and that tackles also this type of crimes. On the other hand, Norway does not have such presence, but they have decided to adopt at the official level restorative justice in the form of so-called cross-cultural transformative mediation as a way to tackle honor-based violence. This is a model which was developed by a Danish mediator of Afghan origins and has been taken up by Scandinavian countries. And they use these as an official policy in state-based restorative justice agencies to tackle this type of crimes. Of course, this study is difficult to generalize. As I was saying, the presence of the communities in the UK is so well developed and structured as in probably no other country in Europe. On the other hand, the resources that Norway has and has invested in these procedures are also not present anywhere else. So they themselves, they sort of discourage other countries to try what they're doing because they can do that by ensuring continuous monitoring. So victims before, during, and after the mediations have alarms on them that they can pull at any time. Helicopters will start flying over the area in which they are found or which they'll leave. They have resources really to ensure their safety. However, this was sort of a good experiment for me to see these two different approaches. And also what I realized is that other countries in Europe are nowadays getting interested into these models. For example, Spain, Switzerland, and they're starting little by little to sort of, if not replicate, but try to get inspired at least by these models.
Thank you. To follow up on what you just said, how transferable are the lessons from this context to other jurisdictions with different legal, cultural, or socio-political landscapes?
Well, I think it would be very difficult to transfer them as such. But what I'm trying to do, and what I try to do with this project, and I'm trying to do also with the next project that I am setting up right now, is to identify, in a way, good practices that sort of mixed up and adapted to the context could bring us forward in the area of victim support, prevention, but also offenders rehabilitation, and maybe also the assistance in this field. So I do think the UK and Norway have been pioneer in the development of these practices. We have certain countries that have not yet adopted legislation and policies in the field of honor-based violence and are following these practices, for example, the UK one. And on the other hand, what is funny to see is that certain countries are nowadays, for example, going for a multi-agency approach, which has been started in the UK several years ago, while nowadays the UK is actually criticizing already the multi-agency approach because they have discovered the downsides of it. So I think the European countries are at different stages, very different stages in this field. So I don't think it would be possible to take something and transfer it somewhere else. But on the other hand, from the pioneering experience of these two countries, we can already see what the upsides and the downsides of these practices are. And we can start adopting the good practices, the best practices or good practices, as we want to call them, into other European countries. And I think this hybridization of practices is the final goal. I held a workshop on forced marriages in Europe last year at the University of Lausanne, with the aim really of setting up a working group of honor-based violence and forced marriage experts in Europe in order to discuss these good practices and started, in a way, harmonizing the systems in the different countries with what we know already that works, and avoiding, of course, the mistakes that might have been done also in pioneering countries. That's the price, of course, of being pioneering. Sometimes you get it wrong.
I mean, your research covers such a wide and complex area. And when I finished your book, I suppose instantly I kind of thought to myself, what were the surprises when conducting this research? Because it is such a complex area. And I imagine that maybe there were themes that come up that maybe you hadn't anticipated, or there were themes that you had anticipated would come up, but maybe they were more dominant than you had previously thought. Could you tell me a little bit about conducting the research and any surprises that came up along the way?
Well, conducted this research at the beginning wasn't easy at all. So I started looking for case studies around 2013, 2014. And I didn't even know, as I was mentioning before, whether I would find something or not. So I had an idea in mind, but I had no idea whether I would find such programs. So I was already surprised to find some. My idea was to bring together the two previous researches that I had done. And so I was very surprised, very positively surprised to actually find programs. During the research itself, I was very surprised probably by one thing, the way in which mediators, also mediators that were external to the communities, for example, in Norway, were able to build trust within these communities and started being recognized as authorities in such communities. There is one mediator in Norway that told me that after a while of working in this cross-cultural transformative mediator cases, she started receiving calls from a certain ethnic minority in the city where she was living, and she couldn't know why they were calling her in case of disputes and of conflicts within them. And they told her, like, you're now an authority in our community. So this process of building trust and being recognized as an authority was really what struck me. Also, I was surprised to see that the presence of women in these programs, both in the official and in the unofficial one, in the community ones, was very, very high, and the trust that they can enjoy within these communities was also very high. And I have to say, maybe the thing that struck me most was, like, after reading a lot of sociological, criminological, and legal literature of these idea that we have of individual human rights, of dignity, of passages from the idea of community to an idea of society in which we're free from the binding family ties in a way. Well, I realized that this is not really the case, and this is not really the case for victims either, and that we need to take into account the fact that in certain areas of the society, these bounds, these levels of social control are still very much present and do matter also for the victims. And so we need to adopt, in a way, a more socially connotated, socially sensitive concept, I think, of dignity and of human rights.
Clara, many thanks for joining us for this LawPod episode on behalf of myself and my colleague, Dr. Elizabeth Agnew. Many thanks for this very, very interesting conversation.
Thank you.
Thank you for inviting me.